We are joined here on the sidelines of Africa Summit taking place in Coventry by a senior, a legal expert, and the former UN Prosecutor, Charles Adeyego Phibbs. Welcome to the program.
Thank you for having me.
You have taken on the challenge to fight corruption in Africa. How is it going on that front?
Very discouraging, and that's for various reasons. Very recently, I was engaged by the government of Nigeria to prosecute some very high-profile corruption cases involving judges in our country, completely unprecedented. The difficulty with that was that the investigations were not terribly well prepared or well conducted. In fact, the judges were raided, their residences, and everything seemed a bit horrid. But beyond that, there was undue interference in the way we structured those cases. And one doesn't know why that is, whether it's due to political pressure or other circumstances. But generally, going beyond the work that I did personally involving the judges, there are quite a few corruption cases going on in my country. And one wonders whether or not, essentially, the government is playing to the gallery. And what usually happens is that we have the Economic and Financial Commission, which is in charge of white-collar crime and corruption cases. So they charge various defendants to court, and it pretty much ends there. And why does it end there? One of the major drawbacks of the strategy, or a lack thereof, is that, you see, before an investigation agency can go about issuing charges and indictments, you have to ensure that there is a strategy and there is a goal. And what that means is that you have to be selective somewhat in the cases you bring before the court. And that's for obvious reasons, because the court infrastructure in Africa is unable to cope, as you will know from the Gachacha cases in Rwanda. So what is eventually happening is that defendants are being charged to court. And these cases go on for 4 or 5 years because the court infrastructure cannot actually cope with the volume of work that is being presented. So we get charges but no convictions. And that's really the major drawback of the fight against corruption, that I have been involved in. Many cases being charged to court, very little progress, no fault of the commission, the investigative commission, but because the courts just cannot cope with that volume of work. And that wasn't factored into it.
You worked in Rwanda as a senior trial attorney under the UN Tribunal for Rwanda. Do you think the court served its purpose?
Well, there are many aspects to the answer to that. The first being, of course, that you know the difficulties and the perception issues and problems that we had as an institution in the early days of our work. And that, of course, was born out of the strained relationship between the government of Rwanda and the UN for reasons that you and I know. We then inherited that as baggage and took on that baggage when we came in. So trying to get some semblance of legitimacy was a challenge. And when we eventually got it, we were open to a lot of criticisms, basically for the slow pace of the work and the fact that we weren't getting as many convictions as we had internal challenges, because, as you know, the work that we were doing was without any precedent. There was no precedent in the world for what we were doing. So we were developing the law, at the same time developing the process and the procedure. So everything was novel. None of us who embarked on this work had ever done it before. And nobody had the experience in the world. So if nobody arrived in Kigali with 2, 3, 4 years experience of prosecuting genocide, it simply just wasn't there. That was one. Coupled with that was the fact that international criminal justice, in all its ramifications, is complex. The various actors, the lawyers that defended the defendants, came from all over the world. We prosecutors came from different legal systems. Common law, I came from the UK. And my colleagues came from France, some from Canada. Now, imagine all of us trying to sit together to agree on legal maxims, what we should charge. The term of a conspiracy meant one thing to a common law lawyer, meant a totally different thing to a civil law, a lawyer from a civil law background. These were all the feeding issues. How do we protect witnesses? The court was not in Kigali. The court was in Arusha. The witnesses were in Kigali, in Byumba, in Kibuye, in Chengugu. How do we move these witnesses? How do we interview them without their neighbors knowing that they're talking to us? How do we collect evidence? The documents were in Kenya, Rwanda. If and when we got them, some were destroyed, some were in French. So there were so many practical difficulties in the work itself. How do we identify suspects? Suspects had fled Rwanda. They were in Cameroon. They were in Kenya. How do we track them? How do we get the cooperation of those national jurisdictions to turn them over to the tribunal? So a lot of people don't understand how complex international criminal law is. Aside from the legitimacy problem that I believe that we had vis-a-vis the local, our host government, the Rwandan government, and other regional governments. So when I say challenges from the perspective of the process itself, from the investigation, getting access to sites. But one of the major challenges for us, and with the benefit of hindsight, now looking back at the work, was the fact that we did not involve Rwandans in the early days of our work. And we paid dearly for it. We paid dearly for it. Had we involved Rwandans right from the beginning, we would have been able to understand certain things that were not obvious to a lawyer like me coming from Nigeria or somebody coming from France. And the reason for that was that the UN had a policy of not wanting to be seen to be taking one side over another. And we had an issue as to, well, we don't know the background of who we're engaging. So we had this policy of distancing ourselves from the locals, beyond the fact that we use them as language translators to take our statements and interview witnesses. But I think we could have involved them more in the initial planning of our work and strategizing of our work, and even in understanding the background of what took place in the country, the history, and what actually took place, what happened here, what happened here, what happened there. So these were some of the practical challenges that when I look back several years later, I think we may have done things differently. But another major challenge, of course, which is unique which wasn't unique to Rwanda, was the fact that the trials were taking place so far away from where the crimes had occurred, and that the principle of justice not only has to be done, but has to be seen to be done, because it aids reconciliation. When I go back to Kibuye to see my witnesses, the first thing they ask me is, Patron, what happened to Kayeshima? What happened to Musema? How many years did he get? We heard on the radio that Baglishima was acquitted. And they're asking for explanations. They want to understand, because you see, they played a role. We've taken them, we've interviewed them, they've come to Arusha, I've sat down with them for days to prepare their testimony, I've led their testimony in court. They have an expectation. But it would have been nicer if they were able to just follow that process, turn on their radio, and they're actually hearing the day-to-day events. Oh, you know, this person said this about Baglishima, this person came and said this about Intakito Romana, and some they will agree with, some they'll say, no, that's not what happened. I was there. And you see, I think that with the benefit of hindsight, that's where the Gachacha system has been a lot more successful, because it's almost like a peer assessment thing where you appear before your local community, you confess to your crimes, you ask for forgiveness, and you know, there's healing right there. I am not so sure that with the lofty work and the great work that we did, that we succeeded in actually getting that whole reconciliation thing. But I think the Gachacha system compensated for it a lot more than that. And thank God that they came up with this beautiful local justice system, tailor-made to Rwanda. And this has always been my position on the future of international criminal law, that there is no point in hurling people off to The Hague, where it takes them 1 month just to get used to the weather. Talk less of the food and the environment. These are people who've never been on an aircraft. Move the trials to where the atrocities took place, be it Congo, be it Kigali, Lagos, wherever, rather than set up this robust institution in The Hague. But can we have a say? Because our leaders don't contribute to the court. The guys who contribute to the court dictate what happens in the court. And of course, in this interview, I'm sure we will talk about the African court and the failings of the African court, or the AU as a whole. Because African governments, there are 34 of them who are members of the ICC, but they haven't really played a robust role in the functioning of that court. I think things would have been a lot different.
And I'm actually coming to that very topic regarding. So let's talk about the African Court on Human Rights. First, how is the court serving Africans? And secondly, how do you collaborate with ICC, bearing in mind most African leaders have dismissed and discredited the court?
Well, the first answer is basically the jurisdiction of the court at the present time does not cover international crimes. So the African Court of People and Human Rights deals with human rights issues and violations of the African Charter. So clearly, at the moment, international crimes are not don't form the jurisdiction, don't come within the jurisdiction of that court. The African Court itself has had limited success. I mean, I remember in 2013 when I left the ICTR, I represented Reverend Mitikela of Tanzania before that court. And that case involved the issue of independent candidacy for political office in Tanzania. Mitikela had decided that there was no political party in Tanzania that had shared the same ideology as he had. But the government, he was so popular and so, powerful that he decided to go it alone as an independent candidate. And the government changed the constitution and barred him from that, right, from being able to stand as an independent. So he challenged it in the local courts, lost, and then took the matter to the African Court and retained me and some others as his lawyers. And we won. And the African Court decided that it was a violation of his rights and freedom of association, not being able to stand as an independent candidate, and encouraged the government of Tanzania to amend their constitution to be able to reflect that. So in that sense, noting that the court had been in existence for a few years, and we were presenting the very first case on its merits in 2012, 2013, it's indicative of the fact that the court hasn't really played that robust a role in adjudicating on cases involving Africans. But that's not without a reason. There is an additional protocol to the court that countries have to subscribe to. And unless your country does that, then citizens can't bring cases before the African Court. The relationship with the ICC, well, the first point to be made is that African governments voluntarily subscribe to the jurisdiction of the ICC. I don't agree with this notion that the court has targeted African leaders. Most of the cases that were referred to the ICC were referred by the African countries themselves, save for the case of Sudan and Libya. But every other case was referred to the court. I think that African countries should take ownership of their own justice system and develop domestic courts to be able to handle international crimes. That's really where things should be heading. the African court could be expanded also to deal with international crimes.
You led high-profile international genocide trials, including former Rwandan finance minister Ndinda Banzi, among others. Looking back today, what is your view on Rwanda's efforts in rebuilding? Because you saw the process.
I am astonished by the development in Rwanda. I go back to Rwanda quite a lot, and since I left the tribunal in 2010, I've been back a couple of times, and I have been really blown away by the level of infrastructural development that has been put in place. I used to live in a place called Kimirura, and I go back there, I don't recognize the place, and the changes, the innovation that has come. It's really, and you know, everybody's talking about Rwanda. It's the best example of governance in Africa, zero tolerance for corruption. It's Africa's best story, and that really, being a post-conflict situation, it's good news. It can be done. It just shows that it can happen. So I'm very excited about Rwanda.
Great. You came here to speak about African governance. What's your take and view on the continent's evolution of the governance?
Democracy has to be seen in context. It's not necessarily the case that Western-style democracy is suited for Africa. I give again the example of Rwanda. Yes, it's democratic, but then again, people will say there's a semi-dictatorship. But that's not even the argument. The important thing is that people fall in line, and there is a structure in place, and they've been immensely successful at that. Same with China. Same with Russia. These are countries that have really been immensely successful. So when we talk about democratic institutions, maybe the time has come for us to put them in some sort of context suitable for our continent because of the peculiarities of our people and our culture.
Mr. Charles Adegu, I thank you very much for joining us.
Thank you for having me. It's been a pleasure.
Thank you.